Does the patent office, become overzealous sometimes with respect to rejecting patent claims when a health tech company wants to patent something that deals with the medical records, digital record technology? Absolutely. That's kind of the headwinds that myself and other practitioners need to look out for and are battling. And so the patent office at policy level wants to preclude anyone from owning these kind of fundamental activities that go on in hospitals. For example, patient data being collected, and they're looking out to preclude any type of patent application that claims an invention on them, because they want to keep that in public domain. They don't want any one person to own the ability of a hospital to organize its files with respect to patient data. And we try to advise clients on certain techniques and strategies.
Welcome to the Digital Healthcare Experience, brought to you by Taylor Healthcare. Subscribe now and stay on the forefront of the digital healthcare revolution.
Hello and welcome to the Digital Healthcare Experience podcast presented by Taylor Healthcare. I'm your host, Chris Civit-Therese, and today I'm joined by Ryan Phelan, an attorney specializing in intellectual property with a focus on helping healthcare clients obtain patents for their innovations. He represents clients from startups to Fortune 500s in patent matters, including regarding artificial intelligence, medical devices, biometrics, virtual reality, imaging, computer networking, data management, encryption and security, among many other things. Ryan has been published in several well-known IP publications, including the World Intellectual Property Review, Bloomberg Law, and IP Litigator. He is also an adjunct professor at Northwestern University's Pritzker School of Law, where he teaches coursework on patenting software inventions. Welcome, Ryan. It's great to have you on the show.
Thank you, Chris. Happy to be here.
And can you start by telling us a little bit about your background and what led you to the law, and specifically specializing in patent law for healthcare technology?
Sure. Happy to do so. I have a computer science background. That's my undergraduate training. And that led me ultimately into consulting in the fintech space primarily, but we dealt with a lot of data at the time on large systems that would consume this data and need to do something very specific with it, usually trading or making some type of decision. I got to see the legal side at Accenture during my time as a consultant / programmer. And of course, it made me curious with respect to law school. So I ended up going to Northwestern Law, doing a joint JD MBA program over there. Got out, decided to do IP law because that closely aligns with my computer background. And, had the fortune of working with a bunch of different clients, including those in the health tech space. And, what I came to find out is a lot of times in the health tech space, especially, in more recent days, with respect to AI, a lot of them are interested in using in silico data to do simulations for purposes of discovering new therapeutics or pharmaceuticals or, any variety of these things that you can do on a computer, with data. And that also includes imaging analysis and whatnot. And so that aligns very nicely with my skills, kind of data processing with respect to healthcare tech for IP. And so I enjoy working with clients in this space using that background.
That's great. And I know obviously the patent process is complex sort of in general, but I think that's especially true in healthcare. Can you talk to us about what are some of the challenges that health tech companies are facing when they're trying to patent innovations?
Sure. There's a particular statute that everyone has to, look out for, not only in the health tech space, but everyone. And that's United States Code 35, Section 101, which has to deal with abstract ideas. And the United States Patent and Trademark Office has gone through various swings, so to speak, interpreting a law that came out in 2014 from the Supreme Court of the U.S., where a particular set of decisions, Mayo and then another one, Alice, came out right back to each other. Mayo sits squarely within the health tech space and had to deal with, biotech. And then Alice sits in the computer realm. And so with respect to healthcare tech, we have to be very cognizant of these two court decisions and how the patent office is interpreting these, which can lead to strategies on how to successfully draft patent claims for a patent application. And if you don't use these strategies, you could end up with a set of patent claims or a patent application that is just kind of dead on arrival.
And I guess sitting from afar, my observation is that, there's been some, I'll say, tightening in the U.S. Patent Office in certain areas. I'm curious, have you seen sort of that trend from your perspective? And then if so, can you explain why health tech patents are often rejected under what I've come to understand is the organizing human activity category? I'm very fascinated by this, and I'm hoping you can explain this all to our listeners.
Yeah, absolutely. So organizing human activity is one branch underneath this Section 101 abstract idea law. Typically comes into play when a health tech company wants to patent something that deals with medical records, digital record technology. And you have, for example, patient data being collected somewhere in a database, and then that patient record data is being used to, do any one of a number of things, such as set up appointments or schedule patients or analyze patient data. And so what the patent office will look at under this organizing human activity is this, one of the key terms is fundamental organizing human activity. And so the patent office at, policy level wants to preclude anyone from owning, these kind of fundamental activities that go on in hospitals. And they're looking out to preclude any type of patent application that claims an invention on that, because they want to keep that in the public domain. They don't want any one person to own the ability of a hospital to organize its files with respect to patient data. And so that's kind of at a high level, that is what the goal is. Now, does the patent office, become overzealous sometimes with respect to rejecting patent claims that are far more narrow and specific than simply organizing human activity with respect to data files? Absolutely, and that's kind of the headwinds that myself and other practitioners need to look out for and are battling. We try to advise clients on certain techniques and strategies to overcome this particular branch of abstract idea, and there's a number of them, and we always take a look at when we get a new invention, if any of these can be applied, these particular strategies.
It's interesting. And I want to come back to that in a minute here, but I'm curious if you can go into a little bit more detail on other trends that you might be seeing in healthcare tech patent approvals. And, are there types of inventions that you're finding it more likely to succeed maybe than others? I guess where are those trends sort of heading right now?
Yeah, so certainly with respect to trends, AI-related inventions are incredibly popular. I've written articles just looking at the numbers of AI plus health tech plus medical tech patents that have been filed in the last few years. And, not surprisingly, there's exponential growth ever since, 2016 is the operable time period. And we've had several generations of AI before AI was thought to be, you have a data set and you're going to train it with a, AI related technique or algorithm such as machine learning or a neural network. And you're going to create your own model, either put it on a server or on a specific medical device or something like this, and use it to, do whatever you want with it. And so that's your own specific AI model deployment scheme. More recently, in the past 3 years, ever since the advent of ChatGPT and the like, we've seen this new generative AI field where, now you have companies not needing to train their own model, at least as robustly. They can, of course, fine tune and update their model with RAG, retrieval augmented generation. But, they're taking these kind of off the shelf models and, using one of those techniques to update it and then applying that to, an end solution. There's a lot of different companies playing around with these Gen AI LLM models that are out there in order to do something that maybe they would have traditionally done with regular AI models or even with more traditional computing code that doesn't involve AI. So we're seeing a lot of that.
Yeah. And as you say, I mean, you've been on sort of the thread of AI long before, ChatGPT sort of made it to the mainstream a few years ago. And I know I've read some of your publications, to your point, going all the way back to 2018, 2019. I'm curious. So as AI and data-driven health solutions continue to grow, how do you see that patent landscape evolving? And I guess, to put it another way, is the technology moving faster, slower, equal speed, and as sort of the regulations, or what are you observing there?
The technology is moving much faster than the regulations. These generations of AI tools that are coming out are very quick. The FDA, for example, was attempting to address just the Gen 1 AI that we had seen coming out with training your own model. And it was interesting to see how they do this, because the FDA traditionally wants to look at a product, and approve it, and that product will presumably stay the same. But with AI, as we know, these models can be upgraded almost instantaneously in some cases whenever you get new data from output of that model. So it can continuously update itself and make itself smarter, or at least more relevant to the data coming in. And so the FDA has been looking at ways to, approve, first model, and then perhaps make a pathway for updates to that model. Of course, anything approved has to stay within certain parameters for purposes of safety, et cetera. And so the FDA's real challenge is to make sure that it's meeting its mandate, and also, perhaps not keeping some of these AI tools from coming out, because some of them can be very useful. I wrote an article with respect to FDA approvals. Most of them are in the imaging category, such as imaging, MRI, images of a patient to detect cancer or whatever it may be. And these types of inventions are thought to be a next evolution in cancer detection, at least in that field. And so they're very important. And I think it's it behoove everyone in the FDA to kind of get a handle on these technologies that come out, but it is very fast.
Yeah, absolutely.
As you mentioned.
And we'll link to those articles just for our listeners. We'll have links to those articles in the show notes. So if you want to read more about those, just go ahead and click on the show notes, and you'll be able to get out to those articles directly from here. So obviously AI is sort of a beast in and of itself inside of the sort of healthcare technology, IP patent space. I'm curious if there are other sort of nuances, if you will, between some of the other types of work that you're doing, whether it's through, software, traditional software, I'll call it, versus, biomedical type of applications versus, you touched on imaging. So healthcare is sort of a complexity in and of itself when it comes to patents. It's fair to say that there are sort of other complexities depending on which realm of healthcare we're talking about, drugs or biomed or software. Take your pick.
Yeah, absolutely. Depending on which one that you're looking at, they're going to have different aspects in play. For example, a pure pharmaceutical in silico data type analysis will happen totally in the machine, and so you want to use perhaps a different patenting strategy there. Want to address the issue of avoiding an abstract idea. Right. Usually that strategy is going to be reciting some type of treatment or prophylactic, some type of output, and it has to be specific to, let's say, a patient. Usually incorporating something like that into the specification and also into the claims will pay dividends down the road because the patent office carves out that specific exception. In fact, examiners have told me that they are looking for that type of exception. So we certainly want to include that where we can. Traditional software cases and, healthcare that uses software can benefit from the gold standard, what we try to look for in all of our patent applications, which is an improvement to an underlying machine. So if you can argue that whatever your software is doing, it improves the underlying machine that it's running on. So let's say it uses less compute cycles, or it stores less memory, or it's more efficient or more secure, then those are things that the USPTO looks for. In fact, some patent examiners, that's all they look for. So you have to, show them the other strategies are also applicable under the manual of examining patenting procedure that the examiners are supposed to follow. And they do for the most part. But certainly the improvement, when I teach my class at Northwestern Law to my students, we always like to bring up the improvement angle. And a lot of times inventors, when you're speaking to them, do not think about the improvement angle because they're focused more on their end goal or in process. For example, in the health tech space, it may be attributes of the product or the pharmaceutical, or if it's a medical device, like what it actually does, the benefit to the user. But the USPTO is not concerned, unfortunately, about the benefit to a human. They're more concerned about the underlying improvement or benefit to the computer, because it needs to be a technical improvement. at least for that type of strategy. Right. And so are we seeing this play out everywhere? Yes. And, does it apply to traditional computer and also healthcare? Yes, that particular strategy.
It's really interesting. And going back to the organizing human activity category and concept, I'm wondering, are there particular strategies that you might employ to get around that particular standard, so to speak? Because obviously, I would imagine that a lot of the activity that we're seeing here in healthcare, you would have to consider that category within the regulation. So how does that particular sort of piece of the law relate to how you might select and modify strategies when you're going after these patents for your clients?
Yeah, so the organizing human activity is one challenge that the patent office can present to you, or one type of rejection under the abstract law. It's actually step 2A, prong 1. It's one of 3. And the remedy to that is doing some of these things that we've discussed by anticipating that perhaps could be challenged with that by the patent office. You can include proactively in your claims the improvement to the underlying machine or the specific treatment or prophylactic. And either, one of 2 things can happen from there. Either the examiner will see it and not issue the abstract idea regarding the certain methods of human activity, or if they miss it, you can raise it in a response to the office action and say this element precludes the patent office from making this type of rejection. Sometimes you need to amend your claims to make that point more clear. But by thinking ahead and preparing a strong patent application with those strategies in place, clients get the benefit.
And I would be remiss, obviously, if we didn't talk a little bit about the new administration here and sort of some of the changes that we're seeing in terms of their, I'll say, sort of philosophy around the size of government and so on and so forth. As you consider future submissions and future clients and so on, how much of that do you take into account in terms of timelines or in terms of changes? Are there things that we should be specifically sort of looking out for as the new administration continues to evolve? I imagine not just this space, but kind of the broader philosophy of government and its role.
Yeah, it's a good question. I've spoken to a few examiners, just, casually asked them, how they're impacted now or they expect to be impacted. And, they didn't really have a good answer. Certainly I know that there's been hiring freezes, which, is not good for, I suspect, for any government agency, including the USPTO, because there tends to be a lot of turnover. And so if that's the case or continues to be the case, then, we could see examiners' headcount become lower, and there's already a backlog. So none of it is favorable with respect to, examiners' positions. One thing that came up was whether or not examiners would have to, return to work, so many days a week, and, whether that means in Virginia or at the headquarters of the USPTO or at one of the satellite offices, it's kind of unknown. So, certainly I would think the current administration wants the USPTO to continue its normal function. In fact, they recently designated a new chair. So, I don't think they're targeting it. And so, that makes me bullish that at least they're not trying to directly affect it or patent prosecution in particular. One of the good things about working in patent law is it typically is not so politically hot, so to speak. And so I wouldn't expect it to be the case here.
Absolutely. And so it sounds like, kind of suffice it to say, it's kind of like everything else, a little bit of uncertainty, still bullish on sort of where we are and kind of managing through the risks of timelines and things like that with clients is sort of the moral of the story.
Yeah, I think so. I think that, we're kind of in a wait and see, and hopefully things shake out good. I do know that the Trump administration did strike one of the Biden administration executive orders that had to deal with, AI governance and, efficacy and safety and things like this. So they didn't necessarily replace it with anything. It's just, it kind of, maybe it was struck just because it was something that was signed by Biden. I'm not sure, but, we'll see if they come up with anything on their own.
Absolutely. So one of the reasons why I love having attorneys on this podcast is you guys seem to have some really good kind of real world stories. And I'm hoping that you can share with us a real world example maybe without violating, obviously, any sort of, attorney-client privilege, so on and so forth. But maybe a real-world example where a health tech patent faced some obstacles, but you were ultimately able to have that patent granted due to a particular strategic approach. So I'll ask you to kind of dip into the bucket of stories you might have and share one with us if you'd be so good.
Yeah, for sure. And I'll speak high level just to protect, confidentiality and identities and stuff like that. But, I'll get patents transferred into me from other law firms or attorneys that, are just having trouble, getting it across the line, so to speak, with the USPTO. And in one particular case, the solution was just following one of these strategies that I had mentioned earlier, adding to the claims a particular treatment or preventative, just bringing that into the claims and discussing that with the examiner was a quick and more painless way than having to bring responses and office actions back and forth between the two parties. So that was fun to kind of get a quick win for the client where, another law firm was saying that it was impossible. Another case with respect to a medical device client of mine that deals with robotics had a particular examiner that was stuck on a pair of references, and we were able to argue that the references or the prior art that the examiner cite, basically saying that the invention is not new to the world and therefore is unpatentable. We're able to show that those two prior art references would not be combinable because one said that it had to do X, and then the second reference said that it could not do X, and it motivated others to not do X in a sense. And so we were able to point that out, and that leads to a legal argument that a person of ordinary skill in the art, such as a medical device professional, would not have combined the teachings of the two references because one specifically says not to do so. And so that was a fun and easy win where we were able to get broad patent claim scope, but without having to amend the claims in any way. So certainly some victories to be had. You have to look under the covers sometimes and line up the strategies and that the examiners in the law want to see and operate according to.
Just seems like there's a lot to keep straight. I mean, you've got sort of a broad macro strategic approaches, and then you have sort of the granular detail about the smaller threads that you can kind of pull on to unwind and ultimately get to your sort of end game. You've got variability, it sounds like, in terms of the attorney that might have had a case before. You've got a variability in terms of the particular examiner that the particular case might fall into with the U.S. Patent Office. I mean, it just seems like there's a lot more that goes into this than maybe some of lay people like myself might be aware of. It's a much more complex process with sort of that high-level strategic element, but then also, I mean, down to the very granular details about very specific words and language within previous patents and what the submission might look like for your client. Is that fair? And how do you keep it all straight? That's a lot to sort of to look at.
Yeah, for sure. I mean, each case is kind of like its own chess game, so to speak. You try to have your opening volley to your chess moves or your first moves out of the gate, and then you see how your opponent reacts. In this case, the opponent would be the patent office, although it's supposed to be not a non-adversarial, back and forth. But sometimes the examiners can get stuck in a position, and you need to move them off, of that with one of the strategies that I mentioned, or just having a conversation with the examiner if they're not really understanding, what the technology is, which can happen, especially if the patent is sent to a technology art unit within the USPTO for an examiner that doesn't understand artificial intelligence, or it goes to a artificial intelligence examiner that doesn't understand biotech, and so it's kind of back and forth. And a lot of times, just explaining things to an examiner in an interview can help set the strategic path. But you have to have your strategy in place when you file the patent application in order to have those kind of going back to the chess analogy, those chess pieces ready to deploy.
Yeah, that makes sense. And I'm interested for your perspective on some of the things that you're seeing that are exciting, that you think are going to be impactful in terms of healthcare tech innovations. I mean, you obviously sit, pretty close to the leading edge, to the bleeding edge, to invention. What are some of the things that just you're personally excited about seeing come through over the next couple of years?
Yeah, I'll be excited to see how machine learning and AI in some capacity is applied to discover, new therapeutics. I mean, Obviously, you can do, drug discovery and operations on in silico data much faster than, doing a bunch of experimentation in the lab. And I know that this type of thing is happening. So it'd be great to see, some of the world's biggest medical challenges solved with at least, some type of AI technique that would have been fundamentally hard to scale with traditional methods, but at least the AI starts out the process, and humans, in the lab or clinicians or whatnot are able to, finalize that product and overcome some type of difficult ailment that we have out there, like cancer, or, you name it. So that would be pretty exciting to see happen.
Yeah, it's fantastic. I know we're almost out of time here, but I'd love to just get final kind of closing thoughts, anything that you're working on that you're excited about, anything you'd like to share with the community. And please let our listeners know where they can go to learn a little bit more about your work and connect with you.
Yeah, sure. Absolutely. All things AI nowadays, I suppose. And, what we're working on at our firm is a tool that allows us to use some of these strategies and develop patent applications faster and more efficiently. So that's pretty exciting to be on the forefront of that. Some of these AI technologies, like you mentioned before, that I write about are often I put on my blog, which is patentnext.com. Again, patentnext.com. You can find a lot of writings, not only in the healthcare space, but generally in the AI or emerging technology space for my law firm, which is Marshall, Gerstein Borun. And yeah, if any listener wants to reach out, I welcome you to do so. I'm Ryan Phelan. You can reach me at rphelan@marshallip.com or at 312-474-6607. All the information is also on patentnext.com.
That's awesome. This was an awesome conversation, Ryan. I really appreciate you joining us today.
Okay. Thank you, Chris. Pleasure to be here.
And thank you to our listeners. If you enjoyed the conversation, please like, share, and subscribe to help us keep growing the show. And if you'd like to learn a little bit more about Taylor Healthcare and the digital healthcare experience, you can go to taylor.com/digital-healthcare. That's our show for today. And until next time, I'm Chris Civit-Therese, wishing you health and good cheer. Take care.
To learn more about Taylor Healthcare, please visit taylor.com/digital-healthcare. This podcast is for educational purposes only and is provided with the understanding that it does not constitute medical, legal, or financial advice or services. The Digital Healthcare Experience is produced by Naomi Schwimmer. Podcast music by Nicholas Bach.
Informed consent is vital to patient care, but how can you help patients make informed decisions? Introducing iMed Health from Taylor Healthcare. Digital tools that standardize and simplify the informed consent process. Go to imedhealth.com to learn more. Find the link in the show notes.